Judgment in the matter of the Queen on the application of tag Eldin Ramadan Bashir and others versus Secretary of State for the Home Department.
Lord Carnwath will explain the judgment of the Court.
There are reporting restrictions in this case. The Court has ordered that no one shall publish or reveal the name or address of the 2nd to 6 respondents or publish any information which would be likely to lead to the identification of them or any member of their families. The order does not apply to the 1st respondent. This appeal concerns a troubling and long protracted dispute about the UK's responsibilities for a group of refugees and their families who arrived in the UK sovereign base areas in Cyprus as long ago as 1998. It raises highly complex issues of international law and its interaction with the domestic laws of the SBAs and the UK, not all of which have been fully addressed in the submission so far received. This judgment is accordingly an interim judgment, giving final rulings on 3 essential issues. In fairness to the parties and in order to reach a fully informed conclusion, the Court sees no alternative but to invite further submissions on the remaining issues identified in the judgment. To summarise the background, in 1960, Cyprus, until then a colony of the UK, had become an independent republic. Its territory comprised the island of Cyprus, but with the exception of 2 areas which were retained under UK sovereignty as sovereign base areas, or SBAs, for military purposes. They have very limited accommodation or facilities for civilians, and they rely to a large extent on arrangements with the Republic for such matters as food and supplies, education and medical support. The respondents are 6 refugees from the Middle East. In October 1998, their ship, bound for Italy, foundered off the coast of Cyprus. They and their families were rescued by SBA personnel and brought to one of the SBAs. In due course, they were accepted as lawful refugees under the UN Refugee Convention by the SBA authorities and permitted to remain. The SBA authorities sought to persuade the UK government to allow them to resettle in the United Kingdom, but this was not acceptable to ministers. Ever since then, they have lived in disused and highly unsatisfactory service accommodation in the SBA, while continuing to press for their admission to the UK on the basis that this is the only practicable way for the UK to discharge its obligations to them under the Refugee Convention. In February 2003, discussions between the SBAs and the Republic about responsibility for refugees arriving in the SBAs led to a memorandum of understanding, which provided in summary for the full range of governmental services to be provided to future refugees by the Republic, but at the expense of the UK. The Refugee Ordinance 2003 was enacted to give effect to the memorandum within the SBAs. The memorandum and the ordinance did not apply to existing refugees such as the respondents. In 2005, an agreement or understanding, the precise nature of which is in dispute, was reached between the Republic officials and the SBA administration that previous refugees would be dealt with in accordance with the 2003 memorandum. This agreement was never reduced to writing. The respondents were unwilling for responsibility for them under the Convention to be transferred to the Republic, and did not accept that this could lawfully be done without their consent. They continued to press for admission to the UK, latterly with the support of the UN High Commissioner for Refugees. The unhappy course of the ensuing dispute is summarised in the judgment. The present proceedings began when, in November 2014, the Secretary of State formally refused entry to the UK, and the respondents challenged that decision as inconsistent with the Convention and brought judicial review proceedings. The High Court held that the Convention did not extend to the SBAs as a matter of international law, but quashed the Secretary of State's decision on the basis that she had failed to take into account concerns raised by the UN High Commissioner. The Court of Appeal reversed that decision, declaring that the Convention did extend to the SBAs and directed the Secretary of State to make a fresh decision on that basis. On 6 July 2017, the Secretary of State made a fresh decision refusing to admit the respondents. In today's interim judgment, the Court gives its ruling on the following three issues. First, does the Refugee Convention apply to the SBAs? Two, if so, does it by its terms entitle the respondents to be resettled in the UK? Three, was the Memorandum of Understanding of 2003 a valid performance of the Convention obligations for future refugees? On the first issue, the Supreme Court agrees with the Court of Appeal that the SBAs are subject to the Refugee Convention. Until 1960, the Convention unquestionably applied to the territory now comprised in the SBAs. The Cyprus Act of 1960 did not alter the status of the SBAs, but merely excluded them from the transfer of territory to the new Republic of Cyprus when it became independent. No further declaration was required to extend the 1967 protocol to dependent territories where the original convention applied. On the second issue, the Court holds that the Convention does not, by its terms, entitle the respondents to be resettled in the UK metropolitan territory. A state's duties under the Convention to a refugee reaching a particular territory for whose international relations the state is responsible are in principle and in normal circumstances limited to providing and securing the refugee's convention rights in that context. Like many multilateral treaties, the Convention was framed to apply only to a state's home country or metropolitan territory, unless extended to other territories under Article 40. Issue 3, the Court rejects the respondent's submission that the 2003 memorandum was not a proper basis for the provision of support for future refugees as required by the Convention. There are uniquely close practical links between the SBAs and Cyprus. Nothing in the Convention is expressly directed to a situation like that which exists in Cyprus, but having regard to the principles applicable to the interpretation of treaties, including Article 31 of the Vienna Convention, the Court does not find objection in principle to supporting facilities required for future refugees being provided by cooperative and effective arrangements with the Republic. Other issues. This leaves the following issues for decision following further submissions. 4. Accepting the validity of the 2003 Memorandum for Future Refugees, was the UK entitled in 2005 to make the same arrangements in respect of the respondents without their consent, given their lawful and accepted presence as refugees in the SBAs since 2000? Was the 2005 agreement a legally effective means of doing so, having regard to its informality and the lack of incorporation into SBA law? And thirdly, has the support of the Cyprus for the respondents in accordance with the 2005 agreement been available in practice? And then lastly, if the answer to any of these points is no, what are the consequences in terms of rights or remedies available to the respondents in the present proceedings against the Secretary of State, and what order should the Court make? So these further issues, absent prior agreement, will be addressed at a further hearing to be arranged as soon as practicable in the new term.